In 1923, Alice Paul proposed the Equal Rights Amendment, aiming to rectify the inequality between men and women, such as unequal pay and treatment in court, as well as other gender-based injustices. This cause is widely supported, yet other results of the amendment, such as eligibility of women for the military draft, are not as popular. For this reason, among others, there erupted a split over whether the ERA should be ratified or not. We believe that, though women have the right to be equal to men, and it is the responsibility of the government to ensure that women have these rights, the Equal Rights Amendment is not the appropriate course of action to secure equal treatment in our society. The disputed amendment formally states the following. Section 1. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Section 2. The Congress shall have the power to enforce, by appropriate legislation, the provisions of this article. Section 3. The amendment shall take effect 2 years after the date of ratification. The ERA seems to help women gain their fundamental rights, but Phil Schlafly, leader of the Eagle Forum, an organization that opposes the ERA, explains how, in actuality, it would not change much for women.
ERA won't give women anything which they haven't already got or have a way of getting. But on the other hand, it will take away from women some of the most important rights and benefits and exemptions we now have.
Many women are not even aware that their equality is not written in ink in the Constitution, because it does not affect their day-to-day life and do not feel oppressed or unequal to men. Those who do feel these pressures and are affected by unfair treatment would not benefit from an amendment simply stating their equality, but more from other, more specific measures that directly address the issue. An example of one of these more definitive statutes is an act in reaction to the disproportionate wages earned between genders for the same work. By 1968, when there was a revived effort to ratify the ERA, a law requiring equal pay for equal work, regardless of gender, had already been passed. Another law was passed in 1964, the Civil Rights Act, outlawing major forms of discrimination against minority groups and women. These two acts alone are great advancements toward rectifying the injustice of oppression of women in society. The ERA does not explicitly cover these issues, so any influence it would have on these particular problems would be minimal and irrelevant, considering these contentions had already been acknowledged and steps had been taken to resolve them. Another problem that promoters of the amendment claim the ERA would solve is legal discrimination against women and mistreatment of them in court. This is a common misconception, as women actually have the advantage in many cases. In most child custody cases, for example, the women are favored and retain custody of the children. To get a deeper understanding of this topic, we asked Derek Cooper, a family law attorney, to share his views with us.
I've been a family law attorney for 6 years, and women take the roles of judge, they take the roles of attorney, and they take the role of client, or the person who actually has a case in front of a judge. And in my experience, men and women judges are treated and respected equally. In my experience, men and women attorneys are respected equally. In my experience, the only time that I see a difference in how men and women are treated is when women and men are fighting for custody of young children. And it seems to me, although no one will admit it, that women are favored when it comes time to deciding which parent young children will stay with the most time. So in my experience, that's the only place that women are favored or treated differently in any way.
With the ERA in place, Schlafly predicts that women will lose this advantage and actually be worse off in most legal situations. She also predicts that the ERA would deny wives the right to financial support and joint income tax returns, rights she and many other women hold dear. A resistance to the amendment also develops from women of low economic and educational status, whose self-esteem and self-image are deeply connected to being wives and mothers. These women want to guarantee that women who devote their lives to their families at home are not awarded lower status than women who work out of the house. A common belief that, with the ERA established, those who have a full-time job running a home and taking care of children will be viewed as inferior leads many to shrink from the Equal Rights Amendment. Aside the Equal Forum in opposition of the ERA, organized labor groups spoke out against the amendment for fear that it would eliminate state protective legislation, which limits the number of hours that a woman can work in certain jobs and guarantees them a minimum wage. The legislation results in an unequal treatment of women and men in the workplace that actually favored women. It argued that the physical differences between men and women would make it dangerous for women to work. The chronic fatigue of long hours would result in the deterioration of women's health, and that future generations would be affected by this deterioration in women's health. Schlafly and others worry that these advantages will be lost when men and women are legally equals and treated exactly the same, despite the usual physical differences between the sexes. The identical treatment of men and women under the ERA would extend to other matters as well. The most widely agitating is the idea of women in combat alongside men on the battlefield. Schlafly dives into this topic in an interview with William F. Buckley, Jr., debating the effects of the amendment on the draft with the National Organization of Women leader Ann Scott.
A great glaring example on which there is full agreement between both the proponents and the opponents is the matter of the draft. Women are exempt from the draft. Selective service says only young men of age 18 have to register. But the Equal Rights Amendment will positively make women subject to the draft and on an equal basis with men. Nor could you have a system whereby the women would get all the nice, easy desk jobs and the men get all the fighting jobs. It would have to be equal across the board, in combat, on warships, and all up and down the line.
Do you agree with that, Dr. Scott?
There is no question that if the Equal Rights Amendment is passed, that women would become subject to the draft. However, I think that we have a situation now where the draft is going by the boards. And furthermore, I think the question is not one of the rights of women here, but it is the question of the draft. Clearly, no sane parent would want to see either child, either a son or a daughter, subject to the draft. But if women are to be citizens and citizens are to be subject to the draft, then women should take the responsibilities as well as the rights of citizenship.
While it seems only fair to share tasks equally between the sexes, we must consider the plausibility of this concept with the natural physical disparity between the sexes in mind, as men typically are stronger in a strictly physical sense. Because women cannot perform at the same level as men, the current standards set to allow only those capable of certain tasks to join the ranks would be lowered. Though this effort enables women to participate, it poses a potential hazard in combat, when women or men taking advantage of the lowered criteria cannot carry out the tasks required of them, which demands more of them physically than what they can deliver. They run the risk of hurting themselves and others. The real issue is not the allowing of women to combat, as there are exceptions, women who can serve just as well or better than men. The problem is the lowered standards that create a possible threat to the safety of everyone and concerns a large population. Equal treatment of women is a huge problem currently, not only in the United States, but worldwide. Although steps toward balancing this injustice are critical, the Equal Rights Amendment is not the best solution to the problem. Other issues arise with the implementation of the ERA, and it may overshadow or obstruct previous appreciated or appropriate rulings. However, despite the inadequacy of this amendment, it is crucial that we take a stand for women and fight for their rights. Until women are truly equal, they are not free.